What's happening, crypto fam? Happy Thursday. Good morning and welcome back to Love for Crypto. I'm Scott. It's a pleasure to have you here. I appreciate you taking the time out to consume the content, so thank you. This morning we're going to talk about Jeremy Hogan giving a cheeky little assessment of the top 5 cryptos and believes Tether and Binance are likely picks for an SEC lawsuit. That's very interesting. I think most of us thought XRP lawsuit would end and everyone else can get on with life. I don't think many of us actually thought XRP lawsuit's going to end and then they'll sue someone else. Or even before the XRP lawsuit ends, going to sue someone else. Let's have a ganders. It is assessment. Jeremy Hogan, top guy, legal briefs, YouTube, get on it. Attorney Jeremy Hogan gave his legal assessment of the top 5 cryptocurrencies, naming Tether and Binance Coin as a risk on the SEC's danger rating. Hogan has been covering the SEC versus Ripple lawsuit since proceedings began in December last year. The US securities regulator alleges Ripple had sold 1.3 billion of unregistered securities over 8 years. The coverage has demonstrated his knowledge of the complex legal subtleties involved with securities law. Based on the analysis, Hogan warns that in his opinion both Tether and BNB are likely candidates for legal action. So the criteria for SEC enforcement in determining a breach of securities law, the SEC has relied upon the Howey test to evaluate whether a transaction qualifies as an investment contract. Under the Howey test, an investment contract exists if there is an investment of money in a common enterprise with a reasonable expectation of profits to be derived from the efforts of others. If that's how they determine what securities are in this day and age, they all just want knocking out, mate. They just knock them out and drag them by the ankles out of the fucking building and get someone else in who's actually just going to go, that's security, that's a not. Yeah. Because this Howey fucking test sounds absolutely ridiculous. The Howey test refers to SEC versus WJ Howey, which the Supreme Court preceded. Over in 1946, the Howey Company had sold zones of citrus groves to buyers in Florida who then leased back the land to Howey. Howey staff tended to the groves and sold the fruit on behalf of the owners, with both parties taking a share in the revenue generated by the operation. Howey did not register the transactions with the SEC, and the Supreme Court's final ruling determined that the lease-back deal qualified as an investment contract. The criteria used to establish an investment contract was an investment of money in a common enterprise, the expectation of profit to be derived from the effort of others. Investment in a common enterprise. XRP is not an enterprise. Drop it straight away. Why fucking about? Why playing games? Spreading FUD. Legitimately, it's an investment of money in a common enterprise. I've not invested in Ripple. Invested in XRP. People who bought XRP haven't invested in Ripple. They bought XRP. Now, someone could have invested in Ripple and received XRP as a gift, but it doesn't mean the purchase. Like you still haven't invested in the common enterprise. Being XRP. What did Hogan say about Tether and BNB? Hogan pointed out that his assessment was not a determination of whether the tokens would win or lose in a securities lawsuit. Instead, it relates to the chances the SEC bring in legal action, in his opinion. Hogan touched briefly on Tether's $18.5 million settlement in February this year with the New York Attorney General. Parent company Bitfinex paid the fine to end the probe into allegations. It had been It had tried to cover up an $850 million loss. The New York Attorney General also raised concerns over allegations it had shortfall of cash reserves back in the Tether in circulation. Hogan didn't discuss how the Tether stacked up against our Howey test criteria, but gave the popular stablecoin a 9 out of 10 danger rating. Now, I'm not telling you to go and sell fucking BNB and all that shit if you've got some. Not telling you to go and sell it. Not trying to scare you. I'm legitimately just sharing an article I've seen, and I'm sharing my opinions on it. In breaking down BNB's situation, Hogan points out that BNB tokens do form an investment of money. He added that the Binance ICO in 2017 also matches the description of an investment contract. Is there investment of money? Yes. Do you buy the coins? You buy the coins. And where did the coins come from? Well, Binance had genuine initial coin offering, an ICO, in 2017. This is the exact thing that Chairman Clayton and new SEC Chairman Gensler have basically said is an investment contract. What's more, Hogan said Binance's operations are very centralized, citing the firm's buyback coin burn policy, which keeps coins scarce, therefore increasing their value, as fitting the narrative of the expectation of profit. He gave BNB and SEC a danger rating of 8.5 out of 10. So he actually rates Tether with a more danger rating, with a slightly higher danger rating. So will the SEC, I mean, like we said in the past, I did expect it to just be over after Ripple. I'm not going to lie now. That doesn't mean that some haven't actually introduced coins in a way where they are actually securities. A lot of people, when you first read what a security is, you sit back and just think, well, that just means a share in a company, surely, a share in an enterprise, a share in a corporation. Crypto's not a share. So, it ain't right. SEC versus Ripple. I've got it summed up here, apparently, in an article. The world of blockchain technology is moving fast, and Ripple Labs is in a top position to lead the finance industry to adopt distributed ledger to its processes, except for the lawsuit the firm is embroiled in. The Securities and Exchange Commission has charged Ripple and its co-founders with an unregistered security offering when it sold XRP since 2012. Both parties are disputing two main points: whether XRP is in fact a security, and if the SEC provided Ripple with a proper fair notice that selling XRP will be deemed a securities offering. In regard to XRP being a security or not, while nothing has been decided yet, the judge did drop a bombshell back in March. My understanding about XRP is that not only does it have a currency value, but it has utility, and that utility distinguishes it from Bitcoin and Ether. As for the fair notice argument, that is currently the most disputed issue in the lawsuit, and is probably the one that could do the most damage to the SEC and its enforcement division for years. If the judge rules that the financial watchdog failed to provide fair notice, that ruling can be used by future cryptocurrency firms and find themselves in a similar lawsuits. Interestingly, the SEC used that as a fear-mongering tactic to ask the court not to give in to the fair notice defense. Ripple, however, states that this lawsuit is anything but similar to past enforcement actions brought forth by the regulator. One main point is that unlike other firms who launched initial coin offerings to raise funds to build their blockchain products and services, Ripple already had XRP in place when it sold the digital assets. This leads to the question, what is the SEC's rationale regarding Bitcoin, Ethereum and XRP? This has prompted Ripple Labs to ask the regulator to turn over its internal documents, which Judge Sarah Netburn approved. The SEC, however, keeps on refusing to disclose that information despite the judge's insistence. Should the regulator remain uncooperative, the judge could order monetary sanctions. You like, who the fuck do they think they are that they can just ignore the judge? Nah, judge, get fucked. Like, what the fuck? Earlier in June, the SEC asked for more time to investigate the case, which the defendants oppose as they contend they had sufficient time to investigate this matter before filing the suit, and because Ripple wants to move for summary judgment as soon as possible. They've had 8 fucking years, bruh. 8 fucking years to file the lawsuit, mate. Ripple recently stated that the SEC has not shown good cause to extend the discovery, and extension will unduly prejudice Ripple's business. And that's probably the regulator's strategy, to threaten Ripple's business as much as it can in order to obtain the best settlement deal possible. Ripple Labs is not like the other defendants. It is well funded and seems to have a case to claim the lawsuit as unprecedented, which could trigger a win in the fair notice defense. It's likely to be the most feared outcome for the SEC, so the regulator will do anything to avoid going there, namely stalling the case to hurt Ripple's business. This is the interesting bit. The blockchain firm also wants to go public once the lawsuit's over. That can only happen if the lawsuit is really over. But a settlement could be costly for Ripple and for its digital asset, as it may bottleneck the flow of XRP into the market for years. In the likely event of a settlement, Ripple's XRP could end up like Block 1's EOS. The latter has recently settled a class action lawsuit after settling with the SEC in 2019. Block 1 rolled over for the regulator, and maybe it was for the best. Should Ripple choose to further litigation, the road could turn rockier and eventually result in a Telegram-like outcome. For now, the judge has extended the SEC's period to complete discovery. The SEC now has until August the 31st to conduct fast discovery, with expert discovery being pushed till October 15th. It's extremely interesting. And like I said yesterday, in my opinion, the SEC just looking like flaming idiots. They look like mugs. They're looking like corrupt, muddy fudders. The corrupt, muddy fudders. That's legitimately what they're looking like, mate, and it's doing my head in. I just want it to be over so we can all move on and the space can really start moving on as a whole, getting clarity across the board. Yeah. So it's time to go to work. Oh, another thing as well. To everyone who invested in Quant, well done. If you invested in Quant back in the day and you put enough in, you'd be a millionaire now. It's another one we missed. Loser. You got to take the L. Chainlink, Quant. If you didn't buy them, you didn't buy them. That's investment opportunity. Don't tell me, right? Don't sit there and tell me that I told people to not invest in Quant. I never attacked Quant as an investment opportunity. I attacked it as technology and an ERC20 token, and I still fucking would today, regardless of its price, right? If it's gone that high and you bought in, you should be a millionaire now, right? But no, you're on Twitter, RIP love for crypto, like a fucking gimp. I'm happy that when your token actually times 10 or times 20, times 30, times 40,000%, whatever the fuck it did, you still feel the need to come on Twitter and acknowledge me, you absolute gimp. So thanks for that, yeah? And everyone else can have one of them, mate, yeah? And take whichever one you want. Thumbs up or fuck you. I really don't give a shit, yeah? And on that note, invest in yourself and invest in internet of value. turn hobbies into revenue, block out the bullshit, live long and hodl it all till you're ready to let it go. We love crypto, love the internet of value, and we love you. So take care of yourself, and I'll see you on the next one.